Folks, we're back. This is Steve Sampson, the Frank Friends, with another episode of Veterans in Politics. We have Judge Michael Villani, Clark County District Court, Department number 17. But before we go to the judge, Frank, you got anything?
Just some questions I'd like to ask him once we start
talking. Have no rants or anything like that? Man, I know you're taking Jim Jonah's place today. Jim Jonah's usually have a few rants.
Okay, a few rants. America, pull your shit together. All of you, Democrat, Republican, left, right, pull your shit together. And just be Americans and humans to one another. We'll start with that.
Well, I can't top that one. Let's go to Judge. Well, you know, if I forget, I want to tell everybody Happy Thanksgiving. And don't invite your family over.
10 or less, Steve, 10 or less.
Have a virtual Thanksgiving dinner. What is this world coming to?
Just be better human beings.
Judge Villani, how you doing, sir?
Just fine, and thanks for having me again. And want to join in. Also, wish everyone a happy and safe Thanksgiving for tomorrow.
Absolutely. Could you give us a little background about yourself?
Sure. I'm a 60-year resident. I am here in Las Vegas. Mm-hmm. I am married. My wife and I have 6 children, 7 grandchildren.
Are you Mormon, Jeff?
No. And she's a school teacher. She's been a school teacher for 25 years.
Clark County School District?
She's worked at a church school.
Okay.
At a charter school and through the school district. So she's been on 3 different school districts. Presently, she just finished up this semester at a charter school for elementary school.
So is she going to run for school board?
No. No.
Board of Ed?
She just wants to be a school teacher right
University
now.
Region? No. Okay. We got that out there.
Right. And I graduated in 1982 from law school. Been an attorney since here in Las Vegas. Started my career at the district attorney's office for about 4 years and was in private practice handling both civil and criminal cases.
Have you ever thought about running for district attorney?
No.
No?
No, I love my job and I'm going to stay on the bench at this time.
I know I keep interrupting.
Right. No, that's all right. And I've been on the bench for 13 and a half years. Was appointed in April 2007.
By Kenny when?
At that time, it was Gibbons. Governor Gibbons.
Oh, okay.
And just finished up the election for another term and look forward to it. Presently, I'm handling criminal cases, and I'm one of 4 homicide judges. That 4 of us are going to. Well, 2 judges, Judge Adair is retiring. Judge Herndon is going to the Supreme Court. Okay. And so we're going to be selecting 2 other judges to handle all the homicide cases. I think we have about 200 homicide cases in Clark County.
That's 200 too many.
Yeah. Absolutely.
Yeah. So, wow, I've known you that long?
Yeah.
Because I met you before when you got the appointment.
Right.
Running for retention. That's when we met.
All right, that would have been in 2008 for the retention election because I was appointed in April 2007.
Right. Wow, that's a long time, Judge.
It seems like yesterday for me.
So when am I going to come over for Thanksgiving?
Not this year.
Not this year. You're not part of the same family, so no, it's just a small event.
So, Judge, tell us why you wanted to be a judge, and why you ran for re-election.
All right. I remember the day. It was the first day at the district attorney's office. We were going through an orientation, sitting in the courtroom watching the proceedings. One of the judges was yelling at both attorneys, and I couldn't figure out why.
What judge was that?
I'm not going to say.
Is the judge still on the bench?
Not on the bench.
And, you can tell. And
I just thought, that is so inappropriate.
Right.
I'm going to be a judge one day and do the exact opposite.
Right.
And so that was a goal from day one in the district attorney's office that I knew I was going to be a judge someday.
Okay.
And then the other part of the question was, why did I run for re-election? Again, I love the job. Still excited by it. I look forward to going to work every day and just want to continue working for the community.
And what about the job that you love?
I'm sorry?
What about the job that you love? What about the job that you love?
Well, it's challenging. It's enjoyable when you have good attorneys on both sides. I learn things new every day, or maybe every week, or maybe every month, but you're always learning something new. I enjoy working with the community, working with the attorneys. And again, it's challenging. It's always learning something new, and I enjoy that.
Well, I'm going to let Frank ask a few questions. Usually Jim will just jump right on.
All right.
No, the judge was explaining himself and some things. So you're talking about the way judges act on the bench and things like that, which I appreciate that you have a different decorum when it comes to things like that. But recently we exposed the judge on the bench who was running for Supreme Court that when he was prosecuting a case, knowingly withheld evidence from the trial that proved that the gentleman was 683 miles out of the state of Nevada, or 836.
Are you talking about Fred Steeds?
Yeah. So he was out of the state of Nevada, and the prosecuting attorney knew this and withheld that type of evidence. As a judge, how would you go about things like that? Why do you see that as a stain upon the bench, and how would you conduct yourself in a situation?
Well, I'm not going to comment on that specific case.
Okay.
I'm not going to comment on the judges involved. It is the duty of a judge is when something like, if there's an allegation that perhaps someone didn't get a fair trial, if it's remanded by the Supreme Court or there's post-conviction relief, that's something I take very serious.
Okay.
And if there's irregularities in the proceedings, and the post-conviction relief, that's where the court determines whether or not there was ineffective assistance of counsel. And for your viewers, I mean, in effect, like malpractice.
Yeah.
But it's called ineffective assistance of counsel. And if the district court judge, such as myself, finds that there was irregularities, there was ineffective assistance of counsel, then we have the authority to grant that person or make that finding, and they would have a new trial.
Okay. So you would definitely want to help cases like that if people brought it to your attention, and you wouldn't want to throw it on the back burner.
No, that's something that's typically filed by a defendant in prison.
Mm-hmm.
I will appoint an experienced attorney to represent. They usually file their pro per petition, which is very general.
Mm-hmm.
It doesn't give us the specifics. And so we want to hear the case on the merits. So we'll appoint an attorney, an experienced appellate attorney, to review everything, to supplement the record. And the district attorney has the opportunity to file a response.
Okay.
And then we would have a hearing down the road and argue the attorneys would argue, the points of law that each side brings up.
Yeah. So you said you basically trial murder cases.
Right. Half my calendar is criminal cases,
Mm-hmm.
everything from gross misdemeanors to, sexual assaults, robbery with use, kidnapping. And then there are 4 judges that have been assigned to the homicide team.
Okay.
2 of the judges, Judge Herndon's going to Supreme Court, Judge Adair is retiring. And so right now it's myself and Judge Levitt. Judge Tiara Jones has taken over Judge Herndon's spot.
Okay.
And I believe in the next month or so, court administration, the chief judge, Linda Bell, is going to be selecting a 4th homicide judge. And perhaps we might have a 5th as well.
Oh.
Okay. It's hard. I mean, with 200 pending murder cases, that's a heavy task for 4 judges.
Going back how long, Judge?
I have a case that's been remanded by the federal court that occurred the conviction was 1990.
Oh, wow.
Mm-hmm.
What
Okay.
happened to fastest?
And so that's 30. I think I might have the oldest case pending right now. Obviously, I wasn't on the bench when that trial took place.
Don't give away your age yet, huh?
Right, but it is from I think it's around 1990.
Wow.
Well, that's interesting you say that, Steve, with the fast and speedy trials. Nevada has the death penalty.
Correct.
We have a brand new execution chamber, and it costs us $860,000 taxpayer dollars. We've not used it, and the last time anybody was executed in the state of Nevada was October 22nd, 1979. And this includes cases like one that's really interesting to me. 79. One that's really interesting to me is Thomas Cash, 52-year-old male, stabbed Ezekiel Devine, 21-year-old male, in front of witnesses. Police recovered the weapon, 100% guilty. And at the age of 52, even if he just lives for 30 more years, because most people live to about 82, taxpayers will pay $2 $2.7 million to keep him in prison and not execute him. Why are people not going with the death penalty? And would you be willing to, if the jury came back with the death penalty, would you be a judge that went with that verdict?
I just want to make sure absolutely clear. I am not commenting on any pending case because that would violate the judicial canons of ethics.
In general,
right.
In general,
okay.
Yeah. Okay.
The jury that's impaneled to hear a murder case, if it's a death penalty qualified case, then they make that decision.
Okay.
The judge does not. So it would be a jury of their peers. A cross-section of our community would be selected to hear the case and make that determination if that's the appropriate sentence.
And the district attorney would have to come up with putting the death penalty on the table, basically.
They make that decision, present it, but it's still up to the jury to decide. And if there is a conviction, then there's various appeals. I mean, on the death penalty, it's automatic appeal to the Nevada Supreme Court.
Yeah.
And like I said, I have a case from 1990. Can't talk about the facts of the case, but you know,
But at least you're saying that you're not going to dictate from the bench. You're going to let the jury do it, come back with the verdict, and you'll basically drop down the hammer when necessary on the verdict.
Well, absolutely. It's I've never legislated from the bench. You know, any judge that likes every decision that's being made is probably not a good judge because your personal opinion should not be part of that. Okay.
I like that.
Sometimes, you know, with the law, it may not be fair to one party, but we have to just, you know, follow the facts and the law and make the decision. And like I said, the majority of the cases are going to be decided by a jury. And so that's strictly up to them. A judge, you know, you may have heard the judge calls balls and strikes. I mean, we make the evidentiary rulings, the pretrial rulings, but the jury comes back and they decide if one side or the other has proven their case, and they make that determination.
So a weird law that I've noticed in the state of Nevada is we're technically not an open carry state, but we're technically not an open carry state. There's no law in the books that state you cannot open carry or that you can open carry. Situations like that, as a judge, do you want legislation, not necessarily you writing it, but legislation that needs to make it more clear to the people, more clear to the trial at hand, more clear to the public, and like, hey, this is a yes, this is a no, like things like that?
Well, on open carry, I'm not going to comment on the specifics of that. It is the duty of the legislators to make laws clear, so everyone in the public knows what is permissible and impermissible. And so, like I said, I'm not going to comment on the specifics of the open carry law.
But that's what I'm saying. You want more clear law, like, hey, this is yes, this is no.
Every law, we want it to be clear.
Okay.
Whether it's for zoning or it's, you know, running a business or what have you. So everyone wants it clear as possible, you know, for zoning issues. I mean, obviously we want that clear. I mean, just every single thing we want it clear.
So you like more clarity and less gray area to people manipulate and work around the law. You want it straightforward on them.
Well, as best you can, but as you know, that any two people can disagree on the wording of a particular sentence. They can disagree on a word in a statute, you know, and so that's not uncommon that there are disputes about a particular word in a contract. I've handled contract dispute cases. You know, like, what did this word mean in the context of the sentence? And there'll be a lawsuit over it.
Oh, wow.
And so that just happens every day of the week.
That's rather interesting, because now there's like laws coming out about like hate laws, like a hate crime. Like if you're part of this group and you do something against this group simply because you hate the group and that group's identity, you get a harsher sentence. You could be federal time and other things added on to, you know, what your standard law would be, like an assault or things like that. With so much in those interpretations like that, like you're saying, you know, what did it mean? What did it mean when they wrote the law? What did it mean with this? Would you be okay with laws that were like hate laws, but more specific? Like, so let's say somebody from one political party committed a crime against somebody from another political party simply because they have different political ideologies. Wouldn't that still be considered a hate crime because you're hating upon their ideology the same as you would be hating upon somebody's religion?
I've met with Steve on a previous occasion,
Mhm.
and he asked me, he said, Judge, are you going to answer my question? And he said it in a nice way, okay? You're asking me a question that could relate to interpretation of a statute,
Oh, okay.
and I am not going to run afoul of any judicial canons.
I understand.
I made a general statement. I agree, and I think every attorney and every citizen would agree. We want the law as clear as possible. We want as few as ambiguities in the law
No
as
room for
possible.
interpretation.
Yeah.
You know,
Well, no
and so
playing with the
that's
words,
that's
yeah.
the goal of the legislators. You know, and it makes a judge's job easier if something is very clear.
Well, like you said, your personal feelings get to go out of it, and you
Absolutely.
get to dictate. Well, not dictate, but you can say, "This is the law. This is what you should have done. This is what you didn't do, and then this is the consequence."
Correct.
So how much discretion does a judge have in interpreting laws?
Well, the judge has to look at the plain meaning of the law that's been set forth by our legislators. Okay, and someone can disagree with our interpretation of the plain meaning of it. Every day of the week, a lawsuit is being filed. So every day of the week, every hour probably, you probably have those stats as far as how many cases are filed per day, which means someone disagrees. You know, I mean, it could be, a personal injury action, can be a criminal action, can be a breach of contract, business action. So here are, very savvy individuals that they disagree on the contract. And if they can't work it out, then they come to the courts, and the courts will work it out for them through a judge making a decision, or when you impanel the jury and the jury decides.
Now, do you think that's because lately in society we've seen words that we've all known the meaning for years for? Now they're being said, well, that's not what that means. This is what I think that means. And then Webster Dictionary will go and update their website and change or add a fifth definitional meaning to it. Or do you think that's part of this problem that you're seeing with the gray areas of these laws and these words?
Sometimes in the statute, a term is not defined, and then that could cause an ambiguity.
Okay.
Sometime that when attorneys prepare when they draft a contract, perhaps they weren't as precise as they should have been. They didn't provide contingencies they didn't provide provisions for contingencies of perhaps why something was delivered late or what have you.
Mm-hmm.
And then they can't agree, and they file a lawsuit if they can't resolve their issue. So there's just so many things that can cause a dispute to come to the courthouse.
Okay. So what's the toughest thing that makes it for you to come to a conclusion in a case that's so heavily disputed on either side when they both got good facts?
It's just the job of a judge is to do the best they can to apply the facts that are presented to the particular law. Mm-hmm. Whether the law is the terms of a contract or the law is, through our Nevada revised statute. That's just our job. That's the tough job that we have, is that apply those facts to this law as we read it.
Okay. Mm-hmm.
You done?
Oh, I got plenty.
Judge, we're trying to propose this new law, and the new law affects it would affect all judges within the state of Nevada, and it's called retain or remove. Okay, and I just want to get your feedback on this. And our argument for this law is that judges have judicial immunity. Okay. Judges, there's no term limits for a judge. They can run as many times as they want. Okay. You can't recall them like you would any other elected official. Judges are the only ones you cannot recall based on the Supreme Court ruling several years ago with the Catherine Ramsey case in North Las Vegas. So how do you get rid of a bad judge? They say, hey, ballot box. That's how you get rid of them. You vote them out. What happens if a judge runs unopposed? And I know many times you have people calling up judges and say, hey, don't run in that election. You should go pack your bags. We're going to run somebody against you. Or attorneys, they don't want to go in front of they don't want to run against a judge because they're intimidated, because they have cases in front of judges, or they don't want to be blackballed by the whole court system because, they figure judges will team up against them and say, why you run against X, Y, and Z? You shouldn't run against that person. So again, how do you get rid of a judge running, a bad judge, and that judge is running unopposed? Okay, so here's my bill, or the bill of veterans in politics. Remove or retain. Okay, so if remove gets more votes than retain, then the seat's vacated. Nevada Judicial Selection Committee takes applications, picks 3 names, sends it to the governor. Governor appoints somebody to fill that vacancy, and then that person runs for retention. Now, based on my argument of why this bill is a good bill, and if a judge is doing their job, they're fair, they're doing the betterment for the community, then that incumbent don't have nothing to worry about. But if a judge is doing a terrible job, ending up in the news all the time, then they know they're going to have a problem with the people. And this way, the people will still have a vote. The people will have a say. The Supreme Court runs Nevada Judicial Selection Committee. They'll have a say. The governor will have a say. The only one that won't have a say is the bad judge that we're trying to remove. So based on that argument, how do you feel about this proposed bill, remove or retain? And let me just say one thing, and I talked to several legislators today. I don't understand why they have none of these candidates when it comes to Supreme Court races. Because none of these candidates means absolutely nothing. None of these candidates can have the most votes, but whoever has the second most votes is going to win. So none of these candidates mean absolutely nothing on the ballot box. So I don't even know why it's there. It's a waste of taxpayers' dollars, printing, paper, and all that. So based on that, I like to have things that's on the ballot box that's actually meaningful. How do you feel about remove or retain of incumbent judges?
Okay. One of the ways to get rid of, as you said, a bad judge is through the Judicial Ethics Commission. It's rare that someone's actually removed.
Actually, when's the last time they ever removed a judge?
I don't recall. Okay, but I'm thinking that is a means they can be removed. It has to go to the Supreme Court, and they would give the thumbs up or down on the decision of this panel. The other way, as you mentioned, is the ballot box. Mm-hmm. And if the attorneys feel that a judge is not doing a good job, then one of them would file, mm-hmm. and then they need to explain to the community why they are a better individual. Mm-hmm. I've been to the National Judicial College probably 10 times, mm-hmm. and we get to meet judges from around the country, and they are amazed that we have the election process in Nevada. I think it's either 2/3 or 3/4 of the states have some form of selection panel or retention panel. Whether it's, I think it's called the Missouri plan, where you're on the ballot and if you receive, I think 60% typically of the vote, you're retained. If you don't, then you lose your job. Right. Other states have a retention panel. And it's made up perhaps with, I don't know the exact makeup of it, but I would assume some members of the Supreme Court, members of the bar, business leaders, and then they would make that decision versus the voters. Right. But like I said, there's 2/3 or 3/4 of the states do have that setup. Nevada does not. And so it would be something that, if you wish to propose it, then they'll need to consider that. But I've been through both. Mm-hmm. I was appointed, went through the judicial selection panel, and then I had to run for retention in 2007. Mm-hmm. Justice Cherry ran for the Supreme Court, won. He had a vacancy midterm. So I went through the selection panel. And, for the people that don't understand what the selection panel is, it's chaired, as you mentioned, by the Chief Justice of the Nevada Supreme Court. I believe there's 10 other individuals on the panel. My panel in 2007 had attorneys from Northern Nevada that didn't know me. I didn't know them. Mm-hmm. They had attorneys here. They had representatives from the state bar. They had a couple business leaders that were selected by the governor. Mm-hmm. And then, so I was interviewed by those 11 individuals I was one of the 3 finalists, and then we're interviewed by the governor, and then he or she makes that determination. So I've been through the selection panel, I've been through the election or retention. I think it's rare that we've had someone get through the selection panel that hasn't been doing a good job. And so, it's up to our legislators to decide. Like I said, 2/3 of the states or 3/4 have a selection panel and a retention type vote situation. And, it's going to be up to our voters to decide if they want that.
How do you feel about this proposed bill, though?
I haven't read your specifics of the bill.
But based on what I said.
I would say generally, from what I've heard from the other judges at Judicial College, I think I'm in favor of the selection panel process because it's not based upon who has the money or the connections.
Or gender.
Someone made a comment that they didn't make it through the panel because they weren't connected. Okay? And I'm not going to address the specifics of who said that or what it applies to. But when I applied, I was a solo practitioner, so I wasn't connected to a large firm. Both of my parents only graduated high school. So again, they weren't business leaders in the community. And so to make a comment that only people connected or they come from large firms, that's just not accurate.
Well, people use that as a tool to justify why they
didn't get it right. Absolutely.
Right.
But it seems like something like what Steve's talking about would kind of bring more transparency and honor back to the bench to where, like the judge we talked about earlier, before he was a judge, willingly and withheld evidence that sent a man to prison for 25 years when he knew the dude was innocent. It would get rid of things like that. Because then other judges would know about it. You'd have like a selection panel like you're talking about, or retain or remove like he's talking about. I think it would bring more integrity and honor back to the bench, and people could, I guess, more relate that when their life's in the judge's hands, that the judge is going to do what's right, because the judge knows not only does it affect your life, it affects my life later, when I'm running, or, just in general, their own ethics.
Well, again, I'm not going to address any case that was through the court system, but I think every organization needs to do a better job to educate the public about judges, because we are the only branch of government, under the separation of powers, that we can't say in advance, this is what we're going to do.
Yeah.
Someone in the legislative branch, they can say, we're going to stop these zoning changes.
Yeah, they're going to promise.
Right. We're going to do A, B, and C, or we're not going to do A, B, and C. From the executive branch to the legislative branch, that's their job.
Yeah.
And so they can say that. A judge can say, I'm going to follow the law. That's all we can say. So we can't take a position in advance and say what we're going to do or not do, besides being ethical and do the best job we can to follow the law. And I think, we just finished our elections here this month. Mm-hmm. And I think that there was issues where the public wasn't aware of all of the candidates, their background. Mm-hmm. And we just have to through whether it's the press, the community leaders, community organizations, to better educate the public. I can tell you, I went through the election and, we did advertising, if you want to call it that, or posting on Facebook. And some people would comment and say, I can tell from those endorsements that he's a member of a particular party, and therefore I'm not voting for him. And they were wrong.
Of course.
Okay?
Of course.
What party? If you're assuming, and so, I got that on both sides of the argument, because I picked up, every endorsement. And so when we would publicize a particular group of endorsements, a lot of people would give the thumbs up, mm-hmm. and there'd be a few people say, well, if he's endorsed by those groups, then I won't vote for him. Mm-hmm. And then on the other hand, if he's endorsed by these groups over here, I'm not going to vote for him.
Well, those are lazy voters. Yeah. Right. Those are voters that don't do their due diligence, don't look into the background. A lot of times when we do when we go and do our endorsement or recommendation, there's a bunch of times we hire a private investigator to go investigate that candidate or that particular judge. and we find out a lot of stuff.
We find a lot.
And we put it out there. Whether people want to pick it up and because a lot of people, if they're friends with a particular judge, they're just going to ignore the evidence. Right. Not even how damning it might be, they'll still ignore it.
And then people voted, straight party lines. Mm-hmm. Now, in federal court, judges can be making decisions, perhaps, more constitutional decisions. Mm-hmm. The big ticket item is, Roe v. Wade. And that's something in the federal court system. As a state court judge, we're upholding state law. Yeah. We're upholding breach of contract, land transaction. I have never made a Democratic land transaction decision. I have never made a Republican breach of contract decision.
Why not? Because they don't exist.
Right, they don't exist. And, so there's, some people say if he's a Republican or he's a Democrat, I'm not going to vote for him. It has nothing to do with the job they're doing, which is unfortunate because, like I said, I've never made a Republican decision or a Democratic decision.
You made a law decision.
Right. And so if someone says, well, he or she is a particular party, therefore I'm going to vote for him, therefore I'm not going to vote for him, it is probably not the best way to select a judge. But, hopefully there's more people that are educated on their votes. But, that's for the political scientists. Someday you can interview them and see, the pollsters.
It's funny, all those poli-sci majors and pollsters get it wrong every year.
Leading up to this election, we had a few judges retired early. Judge Elliott, Judge Steele, Judge Tagliati. Was it Tagliati? Yeah. No, it wasn't. Is it? Yeah.
She's a senior judge right now.
Yeah,
she did retire, but she was senior judge. And
so there was vacancy filled by the Judicial Selection Committee and the governor's office. Judge Smith also retired early. Right. And then we had judges that didn't put their name on the ballot. Judge Carrie Early, Judge Alyssa Ellsworth, Carolyn Ellsworth. Oh, Judge, don't beat me up on that. Judge Carolyn Ellsworth. And then Judge Stephanie Miley didn't put her name on the ballot. So we had a lot of vacancies out there. And one thing I've noticed, if I was just going to look at one particular division, not the civil criminal bench, but the family court bench, and look at the general election, out of 14 incumbents, judges, 13 ran unopposed. And I thought that was just sad. And I went around asking different attorneys, why didn't you run against this judge? Why didn't you run against? And all of them had a fear factor. So if you put these judges on the ballot and have the people vote to keep them or not, I think that would be the best way.
Well, I would always say that the best voter is an educated voter, mm-hmm. And. Like I said earlier, that some people voted because they didn't get it. If you had this endorsement, I'm not going to vote for you. Or if you had this endorsement, I am going to vote for you. And so, I think the thing that we really need to do is educate the voters. If we don't go to a retention vote, if we don't go to a selection panel for everybody, then the next best thing is an educated voter.
But Judge, a lot of the media don't want to report on certain judges. They don't want to report the judge's bad side, or they don't want to report the candidate running against the judge's bad side. So the media is a little bit biased at times when it comes to different candidates in the judicial race. Hence, with Judge Kephart, the RJ didn't want to report Judge Kephart's opponent's negative stuff, which I thought that was unsatisfactory, but it is what it is. But what I'm saying, Judge, this election has opened up eyes to a lot of people. Because we lost 3 judges in the civil criminal bench, Judge Scotty, Judge Bear, and Judge Atkins, which I thought Judge Atkins would have won that myself. But Judge Atkins and Judge Kephart to the opposite sex. Women won all four of those seats. And a lot of people vote on just gender. How do you feel about this election particularly when it came to your race? How do you feel about that?
Well,
And congratulations, by the way.
Thank you. Well, thank you. As you know, there was just 2 judges that had female opponents, 2 incumbents that won, Judge Eric Johnson and myself.
I couldn't find Judge Johnson's opponent nowhere.
I hope that the voters did not vote for, called identity politics. And again, I may have my personal opinion in that regard, right, but I think it's better served by pollsters, political scientists, to come and talk to you and give you their view on why this happened. I ran a positive campaign in every Zoom meeting. I talked about experience and proven track record. And thank goodness that the voters were able to see that. And so I can't really count, I'm not going to comment on any other race. There were some very good candidates and some candidates that weren't as good.
And for whatever it's worth, I think you're an excellent jurist.
I appreciate that.
I think we recommended him, right?
Well, I've always, strived to make, the tough decision. And, we can't be afraid that if we rule against someone, they're going to file against us. Right. If that's what they're going to do, they're going to do that.
That's why remove and retain should come into play, because it wouldn't make a difference anyway. Right. They're still going to be on the ballot.
Right. And that's up to the legislators. Like I said, 2/3 or 3/4 of the states have some form of that.
We just don't, right?
We do not.
Well, you know something.
Actually, I think it was some years ago when Bill Raggio was in the state legislature.
Yeah, I remember him.
That there was, I believe, a bill was presented, or there was some discussion about it, but it didn't go anywhere.
I would like this bill passing this session, but if it doesn't, I have another 2 more sessions to get it passed before the district court seats are up again. So I have plenty of time to perfect the bill.
Now I got a question for you.
Sure.
As an educated voter myself, because Steve's been helping me for the last 3-4 years learn more and more about politics and what's going on in my local area. It kind of ties our hands when we ask judges questions, and almost to a default, your hands are tied in answering the question because you technically can't answer the question for whatever legal reasons, or later down the line, whatever seat you might run for, like they did with Amy Coney Barrett. Like, hey, what do you believe about this? Doesn't matter what I believe. What's the law say? Doesn't matter what I believe. What's the law say? Right. And I understand that.
That's how it's supposed to be.
I get that, but as a voter, especially one who's educated, the other people who are not so educated, I think it would shed more light if maybe judges were allowed to say, hey, like kind of like you said, your legislatures need to fix this thing. It needs to be fixed because it's too gray when it comes into my court. It sucks because it makes the case way harder than it ever needed to be. You guys need to talk to your legislator and fix the wording in this law. Could judges be able to do something like that? Like, hey, this specific law, AB 19, has really bad wording in these 2 paragraphs. Fix it, make it less than 10 pages, put it in common speak, in this crap.
Okay. Judges cannot give advisory decisions. So we can only give a decision when a case comes before us and we're asked to rule on a very specific case.
But you guys have lobbyists that go to Carson City to lobby for different things, right?
We do, on specific laws that have a direct impact on the judiciary. We do have a lobbyist that will give the legislators our view. But as far as a judge giving an advanced view on the constitutionality of a law or how a law should be interpreted, we're precluded from that.
Yeah, that's what I'm saying. I'm not saying in advance. I'm saying you've had 10 cases with law AB 12. All 10 have been horrible because these 2 paragraphs. You know this is what's caused problems in your cases and in the attorney's cases. Like, he should win, got all the evidence, it's on his side, but because of these 2 paragraphs and the way they're worded, the law is interpreted by, like you said, both parties differently, and one just happens to be better talker and gets the jury to be like, hey, look at what I'm saying, better than the other person does. And you can say, hey, I've dealt 10 of these cases, all 10, these 2 paragraphs have screwed these cases horribly, fix it. You can't say how to fix it. You know what I mean? Because like you said, you can't give a prejudgment to it, but like, hey, this is causing issues in the courtroom. It needs to be fixed now. Is there something a judge can do that way that might be able to educate voters as to, I like this judge, he doesn't dictate from the bench, but he saw a problem and he wants it fixed?
I'm not sure on specifics, but I think and I'm glad you asked the question, what we can do to educate the public. Mm-hmm. And let me give you some suggestions. First off, somehow we have to have an ability for groups such as yourself and all the other groups, all the organizations, to give, prepare somehow a background for each candidate. How long have you been an attorney? What type of cases have you handled? What committees, if any, have you been with the state bar? Because that's going to show community involvement. Mm-hmm. Ask the contrary, a view for a judge. What committees have you been on as a judge? For the state judiciary, for the local judiciary? What continuing education class have you taken for the candidate, for the judge? What different positions have you had? How many trials have you had? How many trials have you tried as a judge? And this way, if it's a compare the candidate, graph, I think the voters would be better educated if the parties could take the time to do that. Some people could say that they've had a number of trials. Well, was it short trials or was it the full-blown trials? A short trial is 1-day trial. Each side gets 3 hours to present their case. You have limited time to pick a jury, closing arguments, etc. Or a full trial, which, some trials can, I've had a trial that went 5.5 weeks. I've had a trial that went 2 or 3 days. Let's educate the public. Ask them specifically, why are you running against this candidate? Did you lose a case in front of them? Is that why? Is it sour grapes?
There's no reason to run against the candidate.
Right. Did they rule against you on a motion for summary judgment?
No.
And so
that's called
tell us why.
Revenge. That's revenge. That's this type of revenge.
Right. But I'm talking about even if we could get there, you still don't understand where a judge's mindset is, what the laws are gonna, you know what I'm saying? That's what I'm saying. Is there anything as a judge that you can specifically do to tell voters, hey, I'm a great judge and I want these things fixed because I know they're affecting your lives and they're affecting my rulings because I have to follow this. And this is written just badly.
He said if a judge could fix a bad law.
Right. I wouldn't say fix it, but at least shine a light on it so that the public could be like, hey, we need to take that to the legislator like the judge said to, and this is why. You know what I mean?
Right.
Because it's ruining things.
I don't think that a judge can talk about a specific case. That's why you get in trouble by doing that.
But you can talk about a specific law, correct?
Well, we're saying that this provision is ambiguous. This provision is unconstitutional before a case comes before us. So we would be precluded from doing that. But some of the things that...
So you guys can't do that. You can't say something is ambiguous or something...
No, unless the case is in front of us.
But that's what I'm saying. A law that came in front of you, like I said, AB 12 came in front of you, and you're like, you know what? This is my 10th trial on this law. It's ambiguous. It goes against Constitution. It goes against the 5th Amendment, 4th Amendment. You mean,
right.
Is there something that you can do as a judge, maybe a website or something hey, as a judge, this case was ambiguous. This case went against this. This law went against kind of to help the public that when they click on your name, your website shows them, hey, go look at these laws. It's up to you because, like you said, it's up to us to change them and get them into legislation so that you can then, hey, it's fixed. We can put it down on law. Now we go straight down the middle. There's no gray.
Let me add on to that. A judge is a public figure. Can a judge, and a judge gets elected by the people. So can a judge put it out there and say, hey, look exactly what Frank is talking about?
Just look into it.
A judge could put out, here are my cases that went to the Nevada Supreme Court.
Okay.
That I was upheld here or reversed on this particular case. So a candidate, a judge, can do that. Okay, and let me talk about what I did during this last election cycle, because again, I ran a positive campaign, just talking. Everything was experience and proven track record. Now, in 2018, when I had to split calendar, I had the #1 clearance rate. So I presented that because I think that should be important, that the voters know that if you had a case in Judge Villani's court, he was going to move that case along, because it's not a corny phrase to say justice delayed is justice denied. So I had the #1 clearance rate in 2018.
And I don't think you had a lot of disputes either, right? In return?
No, in this year, from Court of Appeals, Nevada Supreme Court decisions, I think there's been up 39 decisions as of today now. 39 decisions from those two courts. Now, as you know, a decision that comes down today isn't something I did yesterday.
Yeah.
It was more likely, probably the earliest would be 6 months and perhaps 2-3 years. Okay, so today is a decision I made 2-3 years ago. This year, and I would have been affirmed 94% of the time. Okay,
That's beautiful.
and I don't know it's from my parents or me being in sports all my life that I've never wanted to be last in any category. When I went to the selection panel, I told the panel of 11 that I would be one of the hardest working judges. Now, I'm sure you guys have interviewed, people in the legislative branch, the executive branch, and judicial branch. And I'm assuming a candidate or a judge has said that to you. Every candidate should tell you that. Right? I mean, they would be just dumb not to do that.
When you go pull their calendar, you realize that they haven't been working.
Go to the courtroom, they never work on Mondays.
Well, I'm not going to address that. And so I said that to the screening panel. I said that to the governor. And I said that to the voters in 2008. And so, as I mentioned, 2018, I had the #1 clearance rate. Through April 2007 through December 2019, I conducted the second highest number of jury trials of all district court judges. So I kept my promise. And that's another way that we need to educate the voters.
So Judge, why do you think that you drew an opponent and some of these other judges that had a low retention score didn't? That'll be the question.
Social justice, easy pick.
Right.
I'll answer for him.
Because off the top of my head, I could give a candidate that ran against you 5 judges that they should run against. That has a low retention score.
94% approval rate?
Well, affirmance rate by the Supreme Court and Court of Appeals.
Well, that's what
so someone trying to say
of the time, your thing was upheld. They said you were correct in the law.
Right.
So why do you think you drew an opponent?
I thought you were going to ask me that question, and I debated whether or not I should answer that question. My opponent put up a website for Department M in family court, filed in Department P, and on the last filing day, filed against me. And so you'll have to ask them.
I don't think they'll answer, Steve.
I went down.
It sounds like your opponent was confused.
I have no idea.
I don't think we need confusion.
My wife and I went down Monday morning of the first day of filing, and we filed because that's the job I wanted.
Right.
And we always get some candidates wait till the last Friday, 2 weeks, and looking at, well, if I file in this department, I'm going against this person, I'm going against this male, this female. If I file over here, maybe they'll move over here like a checkers game.
Yes.
And this is too important.
Yeah.
If this judge is not doing a good job, then go down there and file against them.
Absolutely.
Not because they ruled against you or the jury ruled against you, not because, wait a minute, they're only numbered, I conduct the second highest number of jury trials in 13 and a half years. So you can say, well, he should have been #1. Okay, well then if that's the reason, okay, he should have been affirmed 95% of the time, not 94% of the time. Then that's a reason. But for some, and this would apply to anybody, I'm not saying just me, if there's other reasons that, that maybe they ruled against you, maybe they awarded attorney's fees against your client, and so you're going to file here. So and I don't think that's the way you should do it.
What about having, you said panels like us, but the problem with our panels is like, you've known, and Steve's known, a lot of judges can't answer certain questions. And those are the questions that people want to know. You know what I mean? And then when you go to try and look up like your retention rate or your, acceptance rate or your approval rate through attorneys, through people that have already tried cases against you. The review journal. A lot of these don't come up. Like we've had candidates where we pulled up their political stuff and I'm like, Steve, the page is blank. Right. Like it's blank. Like their name, no picture, no party affiliation, no percentage rates, no trial this many cases, was approved this. Yours, from what I read, even people that have gone against you were like, yeah, it was a fair ruling. Yep. Like, you see what I'm saying? Like, we don't have that. We don't have that level of transparency. We don't have that level of accountability with the client, the person running. So what else can people do? Or what can you guys as judges, maybe your own website, like not just yours, but like Nevada approved percentages, this the judge's name, this the district, these are the type of trials.
Well, this election cycle, the Nevada Independent sent out a questionnaire to all the judges and the candidates. Mm-hmm. It was a very lengthy questionnaire. I mean, it took hours.
And let me stop you right there, Judge. Sure. I don't. The questionnaires, I don't think it's fair. And the reason why I say this, because I've seen a lot of candidates have their campaign managers fill it out. Right. Or have somebody else fill it out. And it's not coming from the person that's actually running for the seat.
Well, let me tell you, the Nevada Independent created a panel to review the questionnaire. And part of the questionnaire was, for the judicial questionnaire was every case that you've been reversed on. And they went and researched those cases. Okay. And they asked different questions for the candidates. Now, you're right. The questionnaire, you can say whatever you want, or someone can tell you what to say. But then the Nevada Independent received, I think they had 10 or 15 volunteers of some of the top attorneys in town. They had people from Boyd School. They had some law clerks. And so they had prosecutors, they had criminal defense attorneys. They had civil attorneys on both sides of the fence. And they met and evaluated the questionnaire and gave their points of view. So you had someone from the DA's office that might have a point of view, and you have someone from the criminal defense bar. And if those polar opposites can agree that a judge should be retained or this candidate should be voted for, right, then that should carry a lot of weight. And like I said, they had civil attorneys on both sides of the fence, and that needed to be more publicized. But I think that was very helpful, because if you go to their website and you look at the attorneys that were on the panel, they're some of the top attorneys in Clark County, and if some of the top attorneys on both sides of the fence say this candidate should remain on the bench, or this judge should, or this candidate should be selected versus an incumbent, or maybe there's no incumbent like you mentioned, that's something that could carry some weight, because it was a very thorough questionnaire. But again, it was evaluated by some of the top attorneys in Clark County, and I was proud that I received their endorsement. Some of the comments from there were saying, we know when we're in Judge Villani's court, we will always get a fair hearing.
Do you explain your ruling after you rule?
Majority of the time, yes. Sometimes you don't need to because it's obvious. Huh. But sometimes on a close call, whether it's civil or criminal, I will do that. I said, well, I'm not granting this motion because, or maybe this motion is premature. And if there's more evidence on this area, then we can revisit the motion. But right now, I'm denying the motion.
Well, what pisses you off in your courtroom? Is it tardiness, lack of respect for the court? Is it just plain unprofessional, not prepared, attorney not prepared to move forward with his client or her client? What gets your goat? After 13 years, you probably have a few.
I think the unprofessional conduct. And this isn't just from Judge Villani's court. All of us talk. Right. And, it's just amazing that people think that, and it's just a few people, or a small percentage, right, that, if I make personal attacks, well, I don't know why any attorney would think if they make personal attacks against another attorney or against the other attorney's client, that somehow a judge is going to say, oh, well, if you think they're a bad person, then I'm going to rule in your favor. We don't need that. I just want to hear about the facts and the law. And I think the majority, I hope all the judges do that. But there's a lot of personal attacks going on, more so than 10 years ago. And I don't know why that is.
So I can tell you why.
Well, I don't know why it is. But it's just really unfortunate that we've gotten to that point. I had a case against a national organization. So they hired an attorney a law firm that represents them throughout the nation. So you can imagine they were a very good law firm.
Yeah, lots of money.
And it was probably one of the top firms here in town was against them. And as I look back at the case, I remember the case, it was so well tried, and I probably think there was 10 objections for a week-long trial. There's probably more, but just in my mind, there was 10.
Right.
Because they knew how to ask the question, they did their homework, and it was so refreshing as a judge to see that. I could have been at home. They were so professional.
You could have zoomed yourself.
Right. And then there's other cases where there's 10 objections a minute.
Oh, God.
It's just, you don't need that. Be prepared. If you lose something, if you missed a deadline, why are you blaming the judge that you missed a deadline? If you didn't identify a witness properly, why are you blaming the judge because you didn't do that?
Okay.
Some civil firms, some of the top firms, when we have to identify the witnesses, and you're supposed to, on the 16-1 disclosure, you have to say what they're going to testify about. Mm-hmm. So we'll have some attorneys will say, give one sentence. So talk about the facts and circumstance of the case. That did not disclose them properly. There's another firm that will write a whole page. They're going to testify about A, B, and C, including but not limited to the following. So then everything's covered. So who is more thorough?
Yeah.
And then if you exclude the witness from the first attorney, then are they going to be upset at the judge? Well, you excluded my witness because my disclosure was incomplete.
So let me ask you.
But it's their fault.
It's
Right. No, that's in their mentality is, that, they're not a good judge because I didn't get away with the incomplete disclosure.
So I got two quick questions for you. One, if ever need be, would you recuse yourself from a case?
I believe I have done that on one occasion. I think there are recusals that should not have taken place, where I inherited the case from another judge. There was a recusal involving the Review Journal. A reason given by the judge was that they received the endorsement of the Review Journal in years past. That's not a basis to recuse yourself involving the
you
Review
received
Journal.
an endorsement from the Review Journal?
That's it. The gentleman had recused themselves.
Oh.
And then I ended up with it. I had received the endorsement, but it was a contract issue. Mm-hmm. Okay? And if you're afraid to make a decision because you might lose their endorsement next time, hopefully, I couldn't imagine that they would rule, not give you endorsements because of one case. But, that occurred on a case that I inherited.
But that's what I'm saying. So you would recuse yourself if necessary?
Yeah, I don't think I've ever had to recuse it. Maybe once. I can't think of the specific case, but it may have been one time. It's where you cannot issue a fair ruling, and where the appearance of impropriety is so great that you lose the confidence of the community. Okay? Have I, as a practicing attorney for over 25 years, have I had a case against almost every attorney or law firm? Of course. Mm-hmm. So when I took the bench, was I supposed to recuse myself? No, because it's a different day. Mm-hmm. And now it's this case, it's a breach of contract.
This law.
And it has nothing to do with that I had a case against this attorney. I'm just ruling on the facts and the law.
So, do you have a recusal list, Judge?
Do I have one?
Yeah.
No.
Oh.
No, we have to submit.
Do you have anything on your recusal list?
No, we're supposed to provide that where someone's like on a permanent recusal list. Mm-hmm. I do not have one. Because I don't have a situation now. If something comes up,
You would.
I would, have to. Actually, I think there was one a couple months back. It involved a business where I'm friends with one of the owners. And obviously I knew nothing about the case. But when I saw it was that business, I recused myself.
Okay.
Because I have a very strong personal relationship with one of the owners of the business. And I thought it was appropriate.
It looked like
right.
favoritism.
Now, if I knew, a clerk, sales clerk at the cash register at a particular business, no, I would not recuse myself. Right. So I wouldn't recuse myself in that situation, but it was
Right.
So
it was one of the owners, so it was inappropriate for me to hear the case.
my last two.
So I think that was the first
questions-
one. I think that was the one and only one that I had to do that.
My last two questions are.
I thought that was your first question. I thought you had a
Well, because
second.
now he gave me another one. It's a quick one. It's a quick one.
Sure.
If you saw an attorney just completely horribly misrepresenting the person, unprepared, tardy, no evidence, everything's all bad, and you know that either this attorney is better than this or that the person deserves a better attorney, is there something as a judge you can do to be like, yeah, you know what? No, we're going to fix this before this gets too far down the road?
That's happened on two occasions. On one occasion where I called both attorneys into chamber, we took a break. I said, I want to see attorneys in chambers. And I asked, is anyone going to object in this trial? Because there was evidence that shouldn't have come in. There was hearsay after hearsay.
Anybody going to do their job?
Right. And so I asked them that. I brought them into chambers and I asked them,
Right.
is anyone going to object?
Okay.
Okay. Another time, there was someone that I thought was having some issues. And I called them up to the bench and I said, are you okay? And then I continued the case.
Okay.
I mean, it wasn't trial. It was just a hearing.
Yeah, but still,
But I saw it or I felt something was amiss. And I wanted to make sure the record was protected. I wanted to make sure one was a civil case, one was a criminal case.
Okay.
That I want to make sure the parties are protected. Okay, I'm not without taking sides. There was just legal issues there. That's my job.
Okay.
And so I did that.
That reminds me, there was a few years back, Joe, I forgot his last name, it was an attorney that showed up to court drunk and he brought a hooker in there. Do you remember that one that was in the news?
I don't remember the attorney's name and I won't talk about it. No, I remember the video.
He knows it happened.
and that was painful to watch.
Yes, it was.
And you feel sorry for the person, but the judge put a stop to it.
Yes, she did.
Because they felt that this person's rights were not being protected.
So my last question is, we actually, I came up with this idea when Steve was introducing me to more of the depth of family court and things like that, and I thought it would be a great idea. Because you are seeing so much identity politics and things like that, and like you said, you've seen things that go on in a courtroom that should never go on in a courtroom because they're tarnishing what the law in the courtroom is. What would you ever think about a trial or a case in which the judge, the jury, and the attorneys never tell you who or what the client is? They don't tell you whether it's male, female, 35, 21. They tell you this person B stabbed this person A 6 times. This is why. They're not going to tell you who's the mother, who's the father, who's got millions, who has $2, who's, been arrested 80 times. You know what I mean? Like just the facts of that specific case with a letter assigned to each person. No sex, age, gender, race, anything like that. That's how the judge gets to know them. That's how the attorneys know them. That's how the jury knows them. And then they come back with a verdict that can never be tainted based upon personal belief.
I don't know if we could do that for a verdict or jury trial, but I can tell you, and I brought this up during the election, there was an issue about, bias. When I handle criminal cases and I'm doing a sentencing, the way we have it set up in my courtroom is that the case is given a number. And so I don't look at page 1 of the pre-sentence investigation report or page 2 initially, because that will give their name, they'll give who their attorney is, who the DA was. Page 2 will give their date of birth, their race or ethnicity. Okay. It'll give information whether or not they're paying child support. Now, again, this is a criminal case, like maybe it's a burglary or robbery case.
Has nothing to do with the case.
Right. And so the way my law clerks have set this up probably for the last 10 years, I am looking at page 7. This is page 7.
So page 7 is where the meat of the case starts.
And so I'm saying we just have tabs for a number. And so I don't go to page 1 and 2. Mm-hmm. Okay? I'll look at the negotiations. I will go to page 3, which is the person's background, criminal background, if any. Then I go to the offense synopsis. Mm-hmm. So I have no idea who their attorney is, who the DA was. I have no idea race or ethnicity. And so I'm looking at the record, the facts of the case.
But that's what I'm saying. Take it even further. Right. Take their age out. Take their sex out. Take anything that doesn't pertain to this is B's 5th armed robbery. You don't know whether it's a guy, girl, 35, 55 years old, but this is the 5th armed robbery they've done. What's the verdict?
Well, we would know by looking at the 5th. I mean, if their first one was in 1982, so we know we have an idea of their age. But what I have done in my department is just they're assigned a number. So I'm dealing with number 7, not John Smith. Now, and I make my notes. I know what the negotiations are, which I'm still free to go below or above what's negotiated. Mm-hmm. And then so I try to look at it as best I can in the vacuum. Okay? Now, when the case is called, I'm going to know if they're male or female or race or ethnicity or how old they are. But I already have a good idea based upon the facts what I'm going to do. But I listen to everyone. I hear from the defendant, if they have remorse or, unfortunately, sometimes they feel nervous to talk. So I listen to their attorneys, but I do what I can. So I'm not looking at making any decision on that. And I don't think I would ever make a decision on that, but I don't even want to have that in front of me. I want to know like the old Dragnet, just the facts.
Yeah. And on your criminal calendar, when it comes to sentencing, Judge, do you take a person's criminal background into consideration when sentencing comes around?
Well, absolutely. You look at their background, have they graduated from misdemeanors, gross misdemeanors, now they're at the felony, or was their last 2 felonies 15 years ago, and now they have a family, they're working, and they had another bump in the road. Maybe with 3 felonies, the knee-jerk reaction is prison. But now you look at, that's why you look at the specifics of the case, that it's been 15 years. Now, maybe they got back into drugs or something, but they have a family, they have a job. We're coming up in the holiday season, and I always remember a criminal case I had, and I think this will, answer a question about sentencing. There's a gentleman who had a record and is borderline, and I sent him to drug court. And if I recall, the DA wanted me to send him to prison, but I thought I'm going to give him one more chance to drug court. Fast forward 2 years, my wife and I, we went to a butcher shop, one of the few butcher shops in town, and our term came up to the counter, and this person said, "Are you Judge Villani?" And I said, "Yes." It was the butcher with the knife,
Right, that doesn't get scary at all.
He's packing his 9, though.
Right.
And he said, "I was in your court. I want to thank you for give me a chance, sending me to drug court. I got this great job. I'm married now. My wife's expecting, and thank you." Wow. And that made my day. That made my year. Because, we want those success stories.
Have you ever denied anybody bail?
Yeah, so, we go through the analysis now. As you know, there's a Nevada Supreme Court case that came down in April, Jimenez's case. And it's just a situation where we have to go through an analysis, make a specific finding. It's really what we were doing before. But I think, a lot of judges, we weren't making specific findings and, going through an actual weighing process. And we still did it in our mind. But no, we do that. You're not entitled to bail if there's on murder cases. I mean, there's certain things. I mean, proof evident presumption great of the facts. Are they a danger to, this is the analysis that we're told to do, and it's appropriate, are they a danger to the community? What is the likelihood of them showing up for court? And so you have someone that's been an absconder for a year, has, 10 failures to appear. Well, there's not a good likelihood they're going to show up.
No.
You have someone that was out on bail and they committed a new offense. And so, that
When you're on bail, you're supposed to just keep your nose clean.
Right,
I
absolutely.
think so, but there was a woman who was on bail, and when she got out on bail for assault, she went and stabbed her best friend.
Well, that was at that hotel.
Well, I don't know if it's a murder case in front of me or not, but
This one's in
Okay.
Minnesota. With
Okay.
that, it's in front of you.
okay.
Oh, this is a Minnesota
That's
one?
Minnesota
Okay.
case. They bailed her out with that little thing they recently did with all the protesters, and they bailed a bunch of them out. She was the one that got bailed out and stabbed her best friend.
But I think in the past there's too much of a knee-jerk reaction that everyone's going to have a bail versus an OR. And some people are not high risk. Some people have, we don't have a legitimate belief that they're not going to show up, and we don't need to clog up the jail system. But there are individuals that are a danger to the community that have had issues without showing up. Obviously, and if you've been on bail and you commit a new crime, well, that's an issue.
Got the message yet.
Right.
So, Judge, real quick, you said that you're one of four, probably going to
two
be
now, or three.
Two now. Homicide.
It's Levitt, Judge Levitt, Judge Tierra Jones, and myself. And so I'm not sure who that fourth, and we were talking about the fifth, but that's going to be up to the chief judge.
And when it comes to the district court, you sentence people to prison.
Correct.
Okay. Not CCDC.
No, for gross misdemeanors, we can sentence them to no more than 364 days in jail.
Oh, okay.
So, yes.
So it would be at CCDC.
Right.
Okay. Have you ever visited any of the prisons or jails in town?
When I was an extern in the appellate division at the DA's office, while I was in law school, we went out to the Jean prison, which is no longer open. I believe before taking the bench, I took a tour of CCDC.
Do you think it's important for judges, like periodically, maybe every 3 years or so, to have a safari tour at the prison? Just to see,
I'm sorry?
Safari tour of the prison, just to see how, just to see how the inmates are being treated and how staff is working. And
Well, go unannounced though. Don't tell them.
Right. Well, that's one of the things. There's this safety issue, and that is very, it's a concern because, as you know, if there's gang members in prison,
right.
Your standing would go up if.
No, I mean, we're taking all the safety precautions necessary.
Yeah, I'd say bring your own safety team, but don't tell the prison people you're coming. Then we can't start treating people nicely.
Do you think that judges should just visit periodically?
I don't think it's necessary because I think a good judge has to do the evaluation of is there a possibility for rehabilitation versus incarceration? Mm-hmm. And our first look should be rehabilitation. We have a lot of specialty courts. We have veterans court. We have, as you know, we have veterans court. I was in the committee when we created gamblers court. We have mental health court. We have drug court. And so, we have those out there. And so I think the first view should be, can this person be rehabilitated, balancing the protection of the community? And so I rather send someone to drug court because of a drug issue, even though they committed a burglary, than send them to prison. Now, if this is their fifth burglary and they, kidnap someone or rape someone, then
usually they burglarize to get the drugs.
Correct. Or get money to pay for the drugs.
Right.
But then if they're there and they committed a sexual assault or something, well, that is a whole different situation.
Burglarize my house and you ain't gonna meet this judge.
we rather rehabilitate someone than incarcerate.
Right.
But you get to a point at that incarceration is the appropriate option.
Well, statistically, it's proven, especially in Arizona, there's a warden whose prison is horrible, and they have the lowest amount of amenities towards inmates in general. Like they grow their own food, they eat what they grow. He has the lowest recidivism rate in the nation. People do not commit crimes in his town, and they do not come back.
Is that Sheriff Apaya over in Arizona?
I think so. But that's so if it's proven that the harsher they're treated there, the less likely they are to commit crimes again later, how does the justice system balance that? With what you're saying, like, do we send them to a rehabilitation, or do we send them to this Club Fed over here? You know what I mean? Or do we find a different place to send them? Because, like, you know what? This is your fourth time. That's about enough of this behavior from you.
Well, I don't know that it's the best thing to have. The knee-jerk reaction is automatically incarceration, because if they get out, then they haven't been able to solve their drug problem. Well, maybe they've been in custody for 6 months or 9 months, but they still haven't solved the drug problem. They still haven't solved their anger problem. Then all we've done is house them. We haven't helped the problem. We haven't helped our community. We haven't helped that particular individual or their family. And so, I'd rather have someone in rehabilitation than incarceration. But, at a certain point, a certain type of crime, certain type of conduct, incarceration is the appropriate option, again, to protect themselves from the community and protect the community. But I'd rather send someone to drug court and beat their drug habit and then become, a productive member, like this gentleman that worked at the butcher shop. That, I remember that every holiday season, and it's been at least 10 years, and that will always stick with me.
Judge, before we go, I wanted to ask you, do you ask in your criminal calendar, do you ask defendants if they're veterans?
In the pre-sentence investigation report, part of that interview, it'll identify that. I have on occasion asked the defense attorney, isn't he or she appropriate for veterans court? And, I think that's something that the defense attorney...
Say that to you, you got to ask them.
On occasion, I have asked that. And I think that should have been the defense attorney. Okay. Because, if it's related to the veterans issue or their service, there's a lot of opportunities out there, one for Veterans Court, one through the VA. And again, why not solve the problem versus just treating the symptom? Let's put an end to the problem if we can. And that's through counseling or drug rehabilitation. Someone who served I know you served, Steve, but someone who served our country, let's give them that opportunity if because of that service, they've developed an anger issue, a drug problem. Let's get them through the VA. Let's get them through Veterans Court. I've sat in Veterans Court on 2 occasions where I had to cover for one of the judges. And I really enjoyed presiding over that because I saw these people, and there were a couple of people that had graduated different the levels, and they came in.
Has Veterans Court now?
I'm not sure who's doing that right now, and I think there's going to be a lot of new assignments come January, and so I'm assuming we're going to announce who's the other homicide judge who's doing the Veterans Court, and there's mental health, drug court because Judge Ellsworth is retiring. I think she did a good job, and that's a tough job to do that as long as she did. Because, there's a lot of people going through drug court.
Especially now, everybody's isolated.
Now it's all legal, too, in a lot of states.
Mr. Friends, do you have any more questions for Judge Villani?
Questions? No.
Okay. Judge, we want to thank you so much for coming on the program. I really appreciate you coming and talking to our viewers and listeners about your department at the district court level. If you have any closing you'd like to say, by all means.
Right. Well, just to everybody, just obviously be safe, have a great holiday season. And I think next time we have the elections, please do your homework. And I appreciate organizations such as this, as well as, various unions, and they do questionnaires, but learn about the candidates because we want the best people. We don't want someone just because of a particular identity politics, just because a judge ruled against somebody, I don't know that that's the right reason to file against them. And look at their track record and maybe ask them, why are you running against this person? Not just because they ruled against you in your case, but overall, what have they done or haven't done? And that's probably it. Like you had mentioned, some judges lost their position. Whether or not they should have, that's not for me to say. But I think that we have to educate the public about the judiciary, because we can't go out and say what we're going to do. That's for the executive and legislative branch.
Absolutely. Judge Villani, thank you so much for being on the program.
Thank you.
Frank Friends, thank you for subbing for Jim Jonas.
Anytime, Steve.
Folks, this is Judge Villani, Clark County District Court Judge, Department number 17. This is Steve Sanson and Frank Friends, wishing everybody a happy and safe Thanksgiving. Until next time.